Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
She was charged with murder in the first degree.
Hi, this just feels so wrong.
I don't know how much substance this letter has behind it.
This is a demand letter. So all a demand letter is anyone can do a demand letter.
Yeah, I'm a landlord also, and I agree with the previous caller. I think there's a lot of people who are just taking advantage of it.
Under the Federal Care Act, it seems like there have been some, bureaucratic problems.
I don't think it is fair. Nobody's saying it's fair to the landlords.
When there's a lot of news breaking, you can count on our Legal Roundtable to help you make sense of it. Guess what? There's a lot of news breaking. I'm Sarah Fensky. This is St. Louis on the Air. We'll dig into the horrifying case involving a Columbia woman who allegedly pressured her boyfriend to kill the baby he'd had with an ex-girlfriend. What does it take to face murder charges over texts you sent your boyfriend? A young woman is now going to prison, and that's even though she was not present at the scene of the crime. So we'll discuss how and why. We'll also talk about legal attempts to block St. Louis County's COVID-19 restrictions. The county executive's Republican rival sought to sue earlier this month. That wasn't successful. Well, we'll discuss the new demand letter, which was issued by a different group just yesterday. First, though, we want to check in on those moratoriums on evictions. Both St. Louis City and St. Louis County joined the state of Illinois in putting a halt to evictions during this pandemic. But some lawyers now want to overturn those protections. And in some cases, as it turns out, the protections aren't always protecting people. What's going on here? Well, our panel of expert attorneys is here to discuss what the law says and maybe where it falls short. First among them is Bill Freivogel. He's a journalism professor at Southern Illinois University, Carbondale, and he's also an attorney. Bill, welcome.
Hi.
And we're also joined today by Mark Smith. He's an Associate Vice Chancellor and Dean for Career Services at Washington University, as well as an attorney. So, Mark, welcome back.
Thanks, Sarah.
And last but not least, we're joined today by Susan McGraw. She's a professor at the St. Louis University School of Law and director of its Criminal Defense Legal Clinic. So, Susan, thank you so much for joining us.
Thank you, Sarah.
So as mentioned, I want to start off today with this eviction moratorium. The presiding judges of both St. Louis City and St. Louis County have more or less halted evictions since the beginning of this pandemic. Susan McGraw, what gives them the right to do that?
Well, Sarah, there's a couple competing factors. One of the problems is that the courtrooms aren't open. And if the courtrooms aren't open, people can't appear personally in front of the judge. There's been a setup where people can get on a Zoom call. It's really inefficient. It's really difficult for people to make their case to the judge. Most of these tenants are pro se, meaning they represent themselves. They don't have lawyers. So many of them also don't have reliable access to Wi-Fi or cell service or something that would allow them to make that court appearance. And if someone misses a court appearance, there's always the possibility that what's called a default judgment will be taken. They lose because they weren't there. So there's really an inequity of resources that's making this a difficult process.
So this is really a case, in some ways, of logistics. The court just can't pull off the complications of bringing in the very people who would be most likely to need to defend themselves in these sorts of cases. Bill, does that right extend indefinitely? If they can't do these court hearings in person for, say, another year, does that mean landlords could theoretically be out of luck?
Well, the judges have been extending it month by month. So I think they're taking care to, not make this a perpetual, court order. And so they've just been doing on a 1 month or 2 month basis, depending on the conditions. And, meanwhile, both the city and the county are trying to get up and running the the money that could help tenants pay for their rent. Under the Federal Care Act, seems like there have been some, bureaucratic problems, which I guess one would expect in trying to get that going. So that money only is beginning to flow. So it would seem as though it would be really unjust to be throwing people out of their homes when the money is available and on the way and just needs to be processed by the government agencies.
So when you say that, it all makes sense. And yet it sounds like some landlords are chomping at the bit. There's a property management company. They filed a petition Monday seeking a writ of mandamus with the Missouri Court of Appeals Eastern District. They're saying that St. Louis County's presiding judge doesn't have the authority to suspend evictions in these orders that were made in March and August. They're seeking a writ of mandamus. Mark, what's going on in this case?
That forces someone to do something. So, And you've had over in Illinois in Madison County there was a moratorium. One of the judges or one of the circuits was still going ahead with this. Many of these are based on the CDC came out with regulations saying you should have a moratorium for public health reasons. That regulation is being challenged. I think there's a federal suit in Atlanta saying that a number of things, a violation of the Administrative Procedure Act, you didn't jump through the right hoops, saying this is taking power from state and local governments that the Fed shouldn't be doing, some other things. We'll see what happens with that. I think right now it would be tough to say, whether it's Kansas City or St. Louis, you don't have the power to do this. And also, just remember, it's not like these people, come January 1st when most of these end, they're going to owe all that rent. So, it's still there. It's just they can't be put out in the street in the meantime.
So they still will. If they're under this eviction moratorium, they could still have to pay for all these months that they're there.
Good. They will have to pay. I mean, like Bill said, they may get some of this federal money that's is intended to help with this. Their moratorium doesn't say you don't have to pay rent. It just says you don't have to pay it until January 1.
It's interesting, this case that has come up in the Eastern District, the Missouri Court of Appeals, they're saying that they had moved to evict some tenants, and these tenants hadn't paid in January and February. And then obviously everything came down in March. It sort of halted this process of trying to evict these tenants. Susan, it seems like these tenants might have had some spectacular luck. This was not something where they were affected here by the coronavirus in terms of being able to pay rent. They'd stopped paying it before that. And now these moratoriums are giving them a little bit of a grace period here.
Well, everybody deserves a little bit of luck now and again, Sarah.
So you're in favor.
Especially a lot of those folks.
Yeah.
But it does not diminish the amount of money they are going to owe in the end. And, I, for one, my concern is that when you're living hand to mouth, saving that money until January is going to be very difficult.
So this might be a huge problem once this moratorium's finally lifted.
Yeah, it might be. It might be.
One part of this eviction moratorium that I found pretty interesting is a case that came out of our own newsroom here at St. Louis Public Radio. Reporter Eric Schmid noted that in Madison County, as Mark had referred to, people have gone ahead. Lawyers have filed at least 200 eviction cases there. One got as far as the sheriff executing the eviction order. And when the reporter, Eric, talked to the circuit court chief judge, this is Bill Mudge, he said the governor's order, and in Illinois it comes from the governor is where this moratorium came from. It's subject to interpretation. It's been contradicted by other court orders and federal orders. And he said that the courts have received various and sometimes, quote, ambiguous and conflicting eviction directives from the governor, the Illinois Supreme Court, and the federal government. He wrote, no orders entered in the past several months were done so with any purposeful defiance of these ever-changing directives or orders. Bill, should we feel sorry for the judges here? I kind of felt sorry for this guy hearing this statement. It sounds like just a muddle of people trying to solve this problem, but the judges don't even know which end is up.
I don't feel sorry. I don't feel sorry for him at all. I mean, it's just, he just doesn't want to stop doing what they've always been doing, and that's, throwing the tenants out. I think the governor is pretty darn clear that in Illinois that he wanted a moratorium on evictions, and they just keep the machinery going.
Mark, in terms of what's happening in Madison County, do you think that's fair, that the judge should have known he wasn't supposed to do this?
Well, I don't think he was doing it. I think it was other judges in that circuit.
People beneath him.
Yeah, and then once it came to him, he instituted a moratorium. There are exceptions, for people doing criminal stuff. I think he's overstating how. I think the moratorium was pretty clear, and there was something coming for Pritzker. But I think maybe it's a face-saving device. But at least now they seem to be doing the right thing and complying with the law. So I don't think it was as muddied as maybe he made it seem, but maybe he's looking out for these other judges.
We also did have some breaking news this morning. The ACLU has filed a federal lawsuit. This challenges the order in Jackson County with their eviction moratorium. They say it permits eviction cases to move forward in violation of the new CDC order. So there's a whole lot of movement on this front. And I guess the moral of the story is people need to be saving their rent so that when these things finally come due. I see Susan, this is something you'd like to get across to anyone listening. You're going to have to pay your rent eventually, unfortunately. Okay. And we are joined, of course, today by our Legal Roundtable. That's Bill Freivogel of Southern Illinois University Carbondale, Mark Smith of Washington University, and Susan McGraw of St. Louis University School of Law. We need to take a quick break, but we're going to come back shortly to continue this conversation, and we're going to talk about youth sports in St. Louis County and what gives people the right to shut those down. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from Missouri Forest Products Association, committed to sustainable and sound conservation of the state's forests, which support more than 41,000 Missouri jobs, resulting in a $10 billion industry. ChooseWood.com.
Welcome back. Today is our Legal Roundtable, and we're joined by three expert attorneys. That, of course, includes Susan McGraw. She's a professor at the St. Louis University School of Law. She's also the director of its Criminal Defense Legal Clinic. And today we're also joined by Bill Freivogel. He's a journalism professor at Southern Illinois University Carbondale. And we're joined by Mark Smith. He's an associate vice chancellor and dean for career services at Washington University. And just before the break, we were talking about an eviction moratorium. We actually have a caller who has a question or a comment about that, and I'm going to open the phone lines to him. Clint is calling from Illinois. Hi, Clint. You're on St. Louis on the Air.
Well, thank you for taking my call.
Yeah, thanks for joining us.
Glad to do it. My question is, I have a rental property, and I have a tenant who has not been affected by any way, shape, or form by COVID, and he's not paying rent. And I still have to pay my mortgage. I still have to pay my property taxes. I still have to pay my insurance. How is this fair to us who work so hard?
Well, Clint, I think that's a great question. I know a lot of landlords are feeling that way. I don't know if anyone on the panel is particularly interested in taking this one.
I don't think it is fair. The landlords, nobody's saying it's fair to the landlords. I think the government has come in and said, but we don't want these people kicked out of their homes and possibly spreading COVID. So we're doing this. The law strives to be fair, but it's not always fair, and sometimes choices are made, and I'm not suggesting that makes it right for landlords or anything like that. The landlords will still have an ability to sue for their back rent and everything. But if the person is judgment proof, they're not going to be able to collect. And I think, as Bill mentioned, there are some federal programs. They may be able to provide some help as well. But I think it would have been better if the federal government had maybe come in and provided some money directly to these landlords to deal with this issue.
Clint, thank you for that call, and we're sorry you're dealing with this. Frankly, it surprises me that they can just put down an eviction moratorium like this, and it doesn't have any impact on what the banks have to do. Doesn't that feel like a missing piece of the equation, that the banks then don't have to give forbearance to a landlord, or is that a bridge too far? Bill, thoughts on that?
Well, no, it's a good point. And I believe some of the proposals have had provisions like that in them, but I don't think that those were in the final legislation. I'm really not clear about the details of that, but yeah, I do sympathize with the landlord who's in that position. I wonder if it would get his tenant going if he were to point out to him, as Susan has said, they're going to owe a lot of money at the end of this period of time, and maybe they don't want to have a huge amount they have to pay in a couple of months. Better to begin paying.
That's a good point, but I was struck by what Mark said about people being judgment proof. I think those of us outside the legal system, we think, oh, you get sued, you have to pay. It just doesn't work that way. Like, unless there's some sort of asset you can grab, it seems like many times it's worth no more than the paper it's printed on. And it seems like landlords in particular, they're renting to people that don't own homes. They might definitely be in that boat. I want to go back to the phone lines. Lee is calling from St. Louis. Lee, hi, you're on St. Louis on the Air.
Hi, how are you guys doing?
Thanks for joining us. What's your question on this?
Yeah, I'm a landlord also, and I agree with the previous caller. I think there's a lot of people who are just taking advantage of it. I'm looking at a tenant now, and I'm wondering, is she just going to get in there and not pay because of this moratorium? And then when you sue people and try and evict them, they don't have the assets to pay you anyway. And a lot of people just use that as an excuse to stay in your house for a few months and not pay. So I'm wondering, do we have any other alternatives? What happens if you have a drug dealer in your property? Usually you can get an expedited eviction for those type of emergencies.
Lee, thank you for that question. I do believe that in many of these moratoriums, there is an exception for drug dealers.
There is. For criminal behavior, there's a few other things. So there are some of those, but I mean, the people you don't want to tangle with when you're working with the law are either somebody who's super rich, like Bill Gates, who can just fight you forever and has all these high-priced lawyers, and then somebody who's judgment-proof because they just don't care and there's nothing you can do to them. And it's those of us in the middle who have not unlimited assets, but we have something to lose, and that sometimes feels unfair.
Yeah, Lee, sorry for that. An additional example of how this has been tough for the landlords. I do want to move to our next topic, and this is something that it feels like everyone in St. Louis County has been obsessed with, and that is the topic of youth sports. St. Louis County has some restrictions that are more stringent than a big chunk of the country, and certainly more restrictive than the rest of the state, other than St. Louis City. Football and youth hockey games are still strictly prohibited. There was originally a challenge to this that came from Paul Berry III. He's the Republican candidate who's running against County Executive Sam Page in November. He hired Al Watkins. People might remember the name Al Watkins. He was the attorney for the McCluskeys and some other prominent cases. Doesn't feel like this case made much of a dent in the legal system. Susan, is this one you followed?
Yeah, I did follow it. Mostly because I was interested in watching the protests. It really didn't gain a lot of ground. You would have to, in essence, to win something like this, to prove that these requirements were arbitrary and capricious, that there were no real links between the rules and what they needed to accomplish. And when we're talking about public health and a communicable disease, I think that there's really quite a bit of leeway that's given to these guidelines.
Yeah, and certainly this challenge from Paul Berry III was not successful. Just yesterday, another legal action came. It's a demand letter. This is from the Thomas More Society. They're a national nonprofit law firm, and their attorney is Mary Elizabeth Coleman, who's a Republican state representative here in Missouri. Bill Freivogel, did you get a sense they have any sort of claim in this letter as they're demanding that the county repeal some of these restrictions?
Well, I think they have a claim to make. They're saying that the county regulations were not promulgated legally. But if you read the demand letter closely, I mean, at one point they say even if youth sports guidelines were the type of regulation validly delegated to the county to promulgate, that these were not doing anything to try to keep uh, keep the disease out of St. Louis County. Well, I don't exactly follow that logic. It seems to me if they're acknowledging that maybe there is a legal case for them to promulgate the guidelines, that's sort of giving up the argument. That Paul Berry, Al Watkins filing was pretty unbelievable. I mean, I've hardly ever seen a legal document like that had. I mean, they managed to not have any references to any cases.
Yeah,
It was,
that
but
one.
there was a lot of overblown, rhetoric about jackbooted agents.
Yeah, that one felt kind of like maybe they were making some political statements there. I have to say, when I read this one from the Thomas More Society, I thought, okay, they're actually kind of getting into some of the legal framework here, which maybe makes it a more serious thing to discuss than this earlier attempt. But it's hard to know, as somebody who's not a lawyer, whether this is something that could succeed. For example, one of the things that caught my eye, they're saying the county medical director came up with regulations. These regulations now entail criminal penalties. They're saying it's forbidden by the Missouri Constitution for somebody like that, like just a medical director, to come up with something where I could end up getting threatened with jail time. Do you think an argument like that could have a chance of persuading a judge? Mark, any thoughts on that?
Yeah, maybe. I mean, but there's still other mechanisms to enforce these rules. And so also, this is a demand letter. So all a demand letter is I mean, anyone can do a demand letter. I'm saying, I think what you're doing is wrong, you ought to stop. But it's not a lawsuit. And so they're going to have to bring some kind of lawsuit. They're going to have to prove they have standing. They're going to have to prove that the issue, and if you're not subject to it, it might be more difficult. Also, it seems like part of their complaint is this idea that, well, they're playing sports in some places and not in others. But that's kind of the nature of the law. I mean, the law is not precise always, and you have to make cuts sometimes, and it feels really unfair. But the law is not perfect, and so I think, I mean, by the time they'll fight this out, the football season's going to be over. So, Bill, what is?
Sort of taking a little bit broader look at this, that there have been all sorts of emergency applications to the U.S. Supreme Court over the past summer months, and where mostly religious groups have been challenging these various COVID orders that restrict the size of gatherings or the size of religious assemblies. And the court's been rejecting them by a 5-4 vote. Well, one of those five is no longer there. It was the death of Ruth Bader Ginsburg, and so it's very possible that a Justice Barrett would join the 4 dissenters, and so those could end up by the end of the year going the other direction.
What if we had a 4-4 court? What happens if somebody's trying to challenge these COVID-19 restrictions and there is not yet the 9th justice who's seated?
Well, a 4-4 court, the lower court ruling then is in effect until something happens. So it would depend on what the lower court ruling was, and so it would be sort of chaotic because some of the lower court rulings would go one way and some would go the other, probably.
Okay. A lot of this feels chaotic. You had mentioned these challenges as far as many of these were coming from religious groups. This letter from the Thomas More Society, not only did they have a Catholic orientation, but they're also representing private school kids specifically in this. Susan, does that give them a maybe better chance at success or open the door to some legal argument that a public school kid wouldn't have?
I don't necessarily think so. And I think that the phrase they use, and correct me if I'm wrong, is private and Christian high schools.
I think that's right.
So, I haven't seen who, if anyone, is actually the plaintiffs that contacted the Thomas More Society to allege the specific harm. This isn't, the Catholic high school sports association or something like that. So I don't know how much substance this letter has behind it. and exactly how threatened people should be by the nature of this. And I just want to comment on something. Bill talked about how places of worship are trying to file these emergency suits. And, that is a right that is held so dearly in the United States is the right to worship freely. The potential injury that is argued in this letter from the Thomas More Society is these kids might not get to audition their football skills for a college scholarship. So I just want to say they're really not on the same footing as those protesting the right to worship.
It doesn't quite have those First Amendment grounds, that right to play football.
Yeah, it's not, an inviolate right protected under the United States Constitution.
Okay. Well, I had previously mentioned the McCloskeys, and careful listeners of this program may recall that last month I took somewhat of a vow saying that I was done talking about the McCloskeys on this show. And I think even at the time, people laughed at me and said I wouldn't be able to hold that. Well, they were correct. I have to talk about the McCloskeys again, but I promise I'm going to keep this relatively short. And that is the case against the McCloskeys. It is proceeding. They continue to face these charges for brandishing guns at protesters. However, there had been some sort of summons or citations that was issued to some of the protesters who'd gone through the private street that the McCloskeys were on, and they had said they'd heard from the city councilor's office in St. Louis that they were being charged in some way for this. That is now going away. So what do we make of this news? What has happened on this one, Susan?
So, I want to explain a little bit about what it means to get a summons. The police can't file charges in court all on their own against someone. So if a police officer writes you a ticket, there's a process that ticket needs to move through in order to bring you into court. And in a summons, the police are giving you a ticket and saying, okay, I'm not going to arrest you, but I'm going to try and charge you. And if you get charged, here's the information. The city councilor's office in this situation looked at those tickets, looked at the charges the police brought in, and declined to prosecute, which just means those summons aren't worth anything anymore. They're just kind of pieces of paper that the people who are charged can keep or throw out or do whatever they want, because there will be no filing in court of charges.
Well, I got to ask, did the police get ahead of themselves by sending these summons to people? We hear a lot about police applying for charges with, say, the circuit attorney's office. Wouldn't that have been the normal mechanism here rather than just getting these shipped off to people in the mail?
Well, I think that they could have actually arrested people, is an argument, right? They could have taken people into custody and arrested them. That would have been the overreach.
Okay. So you think they showed a decent following of procedure on this?
Yes, I do. I think if you were going to take any actions, the summons was the correct action.
Bill, would you agree with that?
Well, I guess I would have thought maybe the police shouldn't have taken any action. I don't really see trespassing. I know the McCloskeys claim this was trespassing, but the Portland Police trustees certainly don't. And everything, all the pictures I've seen had them on sidewalks, and there's all these sort of legal back and forth about, well, on a private place, where there are delivery trucks and all sorts of and public traffic along sidewalks. Is that really private? Is the sidewalk private property? I mean, I think I would have liked to see the police be more restrained.
It's interesting when you see all the crimes that happen in the city where people say they're calling 911, they can't get someone to come out to their house. It's interesting to think of the time it would have taken the police to go through these photos that were in the news media and identify these 7 people that they identified and go to the trouble of sending a summons. Mark, what's your take on this?
I don't know. I mean, I'm not sure when they issued the summons, if they gave them to them at the time.
It was later.
Yeah. But, I mean, I think Mike Garbutt in the city councilor's office did the right thing by dismissing them. They investigated, so nobody can say, oh, you're not taking it seriously. With 20/20 hindsight, I probably would not have given them summons. I agree with Bill, but I don't know that it's the end of the world.
Yeah.
And I think it all came out for the best.
In this case, at least, our panel agrees. The city councilor's office did the right thing. Okay. Well, our legal roundtable today, that was just Mark Smith speaking. And we're also joined by Bill Freivogel and Susan McGraw. We need to take a quick break. And when we come back, we're going to talk about just a really horrifying case involving a murdered infant in St. Louis City. This is St. Louis on the Air on St. Louis Public Radio, 90.7 KWMU.
Support comes from the Missouri Forest Products Association, committed to conservation and careful management of the state's forests to make them more resilient and better habitats for wildlife. ChooseWood.com.
Welcome back. You're listening to our Legal Roundtable, and today our guests include Mark Smith, an Associate Vice Chancellor and Dean for Career Services at Washington University. And that's in addition to Bill Freivogel, a journalism professor at Southern Illinois University, Carbondale, and Susan McGraw. She's a professor at the St. Louis University School of Law and director of its Criminal Defense Legal Clinic. We're particularly glad Susan is here with us today because we seem to have an unusual number of criminal-type cases to discuss today. And this next one, unfortunately, does fall under that. Earlier this month, a young woman named Emily Paul pleaded guilty to involuntary manslaughter. Prosecutors say she persuaded her boyfriend to kill his 3-month-old son. He'd had that son with another woman, and they apparently broke up at some point, and he got together with this girl, Emily Paul. She was originally charged with first-degree murder. Prosecutors ended up reducing the charges to get to a plea agreement, and now she's facing, she's going to do 4 months in prison. Then she'll serve 5 years probation. And if she violates that, she could have up to 10 years in prison. This is a pretty serious sentence here. Susan, in light of what she's accused of doing, do you think this is a fair sentence?
Well, I don't know enough about the case to, from a factual standpoint, I'll say this. She was charged with murder in the first degree. And the only punishment for that is either the death penalty or spending the rest of your life in prison without getting out.
Whoa.
So what she was facing was really an enormous amount of punishment. Also, she was charged in a way that's called acting with another, so that she was going to be held responsible both for what she did and for what the father of the child did. So there was no way for her to say, well, just look at what I did, because they were charged with acting together. In light of the penalty, in light of how little jury appeal a case like this would have, she decided to plead to something that carries a much, much lower sentence. Mm-hmm. And that's very common.
To take that kind of plea in a case like this.
Right, because if you gamble with the trial, and a trial is always a gamble, and you lose, she'd never get out of prison. All of a sudden, 4 months looks like a really good deal.
It's interesting. According to the St. Louis Post-Dispatch, prosecutors reduced her charge to manslaughter because her messages to Baker, that was her boyfriend, never explicitly instructed him to murder Aiden. But she did exert emotional pressure. Bill, does this seem unusual, where emotional pressure could end up leading even to involuntary manslaughter, much less first-degree murder?
Well, there have been cases in other parts of the country where, there was that case a couple of years ago where girlfriends sort of urged her boyfriend to go ahead with a suicide, and she ended up being prosecuted. So, yeah, I do think the fact that she never explicitly told him to kill the child is, one reason to keep it away from first-degree murder. Mm-hmm. But this does seem a little bit on the gentle side.
It's interesting. She apparently was hounding him before the child's death. She said she didn't want to be a mother to 2 children that aren't mine. And she called these sons a burden in the relationship. But her attorney, Joel Schwartz, he works with Scott Rosenblum's office, a very good attorney in town. He says that she truly never believed something like this would occur. Mark, do you think if she had decided to take that gamble, which, as Susan says, there's a lot of good reasons not to take that gamble. Is there possibly an argument here that this was just a boyfriend and girlfriend talking? This is her First Amendment right to free speech here.
Well, that would be their argument. And like Bill said, this is very different from that Massachusetts case. There, the woman told the guy, why don't you get back in this truck, where he was trying to kill himself. There was nothing explicit like that. It's a horrible case, and people want to, want to have her to have more of a penalty. The father is, I think, in prison for like 30 years or something. Mm-hmm. She was under involuntary manslaughter, which would be like, the classic example is if I shoot a gun in the air and if the bullet hits somebody, it's reckless, it's negligent. That's more like it. Or I think this one also in Missouri would be like if I were drunk driving and killed somebody. So, she wasn't forming the intent to kill. We don't know what's in her head, but they certainly couldn't prove that.
Mark, when you describe this as sort of reckless, she's putting a gun in the air, I guess to some extent that does kind of fit this. Like she's behaving recklessly with a man who's in a mental state where then he did something horrible.
Yeah, we don't know how much she knew about his mental state. I mean, it's hard to believe anyone would be capable of doing this. She was complaining about him paying child support, but there was no evidence that she was saying, and you should eliminate this kid.
Mm-hmm. Susan?
Yeah, so under Missouri law, someone acts recklessly when they should know that it's practically certain a certain action will occur. It's the lowest mental state we have, right? I mean, it's when we talk about murder first, we mean they have thought about it and they intend to do the action. The mental state on reckless is very low. And I think the interesting issue is whether or not words, right, saying words would really establish that you're certain an action's going to occur. We're not going to know because she took a plea, but it'll be worth following to see if the circuit attorney tries something like this again in the future.
It is interesting, this Massachusetts case, which I believe Bill was referring to. This was a teen named Michelle Carter who basically harangued a young man into killing himself. I mean, this case was terrible. And that was apparently the first in Massachusetts to consider manslaughter charges tied to texting. And this seems to be sort of advancing things even past that. Do you think we're going to start seeing more cases like this where instead of people having these emotional phone calls where we say terrible things to each other, we're leaving a paper trail every time we say something this terrible? That maybe people will be held account when they're having these kind of conversations with a loved one and spurring them on to do something this terrible. Mark, do you see any movement towards this could become more of a growing field?
I mean, I think there'll be pressure for prosecutors to bring these kind of claims, but I think it's critical that she pled. And I think what Susan said at the beginning, this is a horrible fact pattern, and I bet her lawyer is saying you don't want to get in front of a jury because they're not going to care what the law is. All they're going to know is you were telling, and some baby died, and you're going to go to prison. So let's cut a deal and go for this. I mean, I think there's a good chance she might have won on appeal, saying, "Hey, I never said this, so I don't even fit under involuntary manslaughter. I was just telling them I don't like these kids being around, and there's no way I could have anticipated, and that I would meet this minimum mental state standards." But I think, there's going to be pressure on prosecutors when you have this bad a fact pattern.
I want to go to the phone lines.
I was going to say, I think there's no doubt there'll be a lot more cases involving social media like this.
I want to go to the phone lines. Karen is calling from Baldwin with a question for our panel. Karen, hi, you're on St. Louis on the air.
Hi, this just feels so wrong to me and so lenient. And it's no surprise that she was represented by what some of us refer to as the Scot-free law firm. That's who you want. But my question is, would the sentencing possibly have been different if an adult, say like a wife or a spouse, had been killed? Because it seems like in America we still treat children like property, like chattel. And the murder of a child doesn't hold the same weight as the murder of an adult. And I'll take my the comments responses off the air. Thank you.
But that was a great question from Karen. Karen, thank you for that. Does anyone have any thoughts on, say that Emily Paul's boyfriend had murdered his ex-girlfriend because of this instead of this 3-month-old baby? Susan, do you think there'd be a different outcome here in terms of the sentence?
She might not have pled at all if it was an adult. An adult killing another adult is seen as a fair fight, right? That adult could have tried to defend themselves unless they had some vulnerability. But when you're talking about a child, people have the reaction that Karen has, which is, look, don't tell me what the law is. Someone's going to pay because this child is dead.
And Mark, I see you nodding. You agree with Susan's assessment?
Completely.
Yeah. Well, it's such a sad case, and I can see why it's just talking about it is so depressing. Let's talk about something else. I want to talk about a case in Oregon County, Missouri. Am I saying that right? I've never been to Oregon County. I know they pronounce things differently in this state. Governor Nixon, former Governor Jay Nixon, had engineered the purchase of roughly 4,200 acres along the 11-Point River. Well, now an Oregon County circuit judge has ordered the state of Missouri to sell parts of this planned state park. And it turns out it has to do with federal easements. This case, reading about this in the Post-Dispatch, I was pretty confused on what could possibly get a judge to this point. Bill, any thoughts on what's going on this case?
Well, the judge. I have to say, I also, Sarah, you also sent us Jay Nixon's op-ed explaining why he disagrees with the judge, and I even though I like to just disagree with Jay Nixon, I think he's sort of right on this one, that the judge is, his judgment is not very detailed. He doesn't look at the fact, as Nixon points out, there are lots of other state parks where there are easement issues. I mean, I can't imagine how he could, have this order for the state to sell this property without having looked at what's the situation in other state parks. So it's a very thin, short, thin order without a whole lot of legal reasoning. I mean, the judge basically says, because there is a federal easement on some of the river through this where the park would be, that's going to keep the park from being able to be constructed the way it had been planned, and so therefore they have to sell the land. And it seems as though, at least according to Jay Nixon's argument, that there are lots of parks around the state where there are these easement issues that are easily worked around.
Yeah, the judge called the state's purchase arbitrary and capricious. I don't know that I've ever heard that applied to the actions of a state government before. Maybe I'm just not paying attention. Mark, what do you think about this one?
Well, arbitrary and capricious, we lawyers, we love to say that. And that's anytime we want to say you did something wrong. So, my kids now know that, and they'll characterize my punishments of them as arbitrary and capricious. They've learned
a compelling argument from your kids.
Yeah, exactly. It just doesn't make sense to me, even after I read the judge's decision, because there's a half-mile easement along the river. So people could still use the river, float down the river. You just can't build stuff on that half hour, and it's a park. So that's kind of what you do with parks. You just leave them in a natural state. It makes a big deal of, well, you couldn't put your boat in. But, I don't know, and who are you going to sell it to? That's what I'm not completely clear on. It seems like, I think people were upset when Nixon, this is lead money from and this was not an area hurt by the lead industry. So some people were upset about that. I think some people were upset because there was some talk about naming it after Nixon. And so the Republicans were kind of worked up about that. But I mean, this seems like I've never been there, but when you look at it, it looks like a beautiful spot. It looks like it'd be perfect for a park. And I don't get this, and I hope the state would appeal this ruling.
So, yeah, this op-ed that Bill mentioned that came from Governor Jay Nixon, he's saying he seems to feel that there's a chance the state might not appeal this decision, and he wants to really spur Attorney General Eric Schmidt to file an appeal in this case. It seems like the appeal might come down to politics rather than the merits of the case on this one, is at least what he's afraid of. Susan, do you think that's a valid fear?
Well, it wouldn't be the first time it happened in the state of Missouri or probably any other state. And I think the plaintiffs, you say who would buy that land? I think the plaintiffs are the people who own the land next to it. So I think that's your answer for who would buy that land.
Wow, I guess that question is now solved. Susan with the sleuthing. Bill, thoughts on this?
Well, I just would say I think the Attorney General had said he wasn't sure whether he was going to appeal, and I think there's a house of the legislature that voted it should be sold, and that was by a Republican majority. Just to back up Mark's comment about arbitrary and capricious, Thomas More and Al Watkins thought Page's rules on sports were arbitrary and capricious as well. So it's a well-worn phrase in the law.
It sure sounds good. It doesn't always hold up. Hey, I got to break in here. We have about 3.5 minutes left of conversation, and we have some breaking news. This is breaking legal news, so it's a good thing I have my panel here. I might want to get your reaction to this. Our news partners at 5 on Your Side are reporting that a federal judge has dismissed St. Louis Circuit Attorney Kim Gardner's lawsuit against the city, police union, and others. This lawsuit accused them of a racist conspiracy to force her from office. U.S. District Judge John Ross wrote, quote, her 32-page complaint can be best described as a conglomeration of unrelated claims and conclusory statements supported by very few facts, which do not plead any recognizable cause of action. Now, that lawsuit alleged civil rights violations as well as violations of the Ku Klux Klan Act of 1871. And 5 on Your Side reported that they are still awaiting comment from Gardner on the judge's ruling. This case got a lot of headlines, got a lot of national press when it was filed. Mark, are you surprised to see John Ross throw this out?
No, and I can't remember I remember reading it, and we talked about it in a previous show, and it was just a lot of conclusory statements, and I don't think it was. It didn't seem to have anything legally that would. So I'm not surprised by that. Having said that, I mean the Police Officers Association has been. I'm not defending all the stuff they've done, and I think it's been inappropriate, but I'm not sure it rises to a level of a federal lawsuit.
Bill, you are a media critic at times. Do you think this was designed to get the national media coverage that it got, as opposed to actually advancing within the federal courts here?
Well, it probably was designed to get national media coverage. She was never going to win this case. The Supreme Court's made very clear it's a very high bar to win a case like this. But as Mark says, I mean, there's, and I would go, I guess, a step further than Mark. I mean, there's clearly, this is the Ku Klux Klan Act case. There's clearly a racial element to what the Police Officers Association has done, and I think I think Gardner had some reason to feel as though the grand jury the special prosecutor's investigation of her handling of the case involving the former governor, it might have had a little bit of a racial element to it as well. Mm-hmm. So, but she wasn't going to win this case.
And we have talked on past roundtables about the idea of the Attorney General trying to take concurrent jurisdiction from Kim Gardner and whether there's a racial element to that. Certainly some of our panelists have felt that way. We should note that went down in flames. The House did not end up acting on that. So, Susan, I guess Kim Gardner, she has basically been reelected. She still has to beat a Republican in November. But it seems like maybe she still is winning, even though she lost this.
Yeah. This suit was filed before the primary, and there are people who would say it was a way to get out her platform to the national media. And certainly putting it in a federal lawsuit gives it more gravitas. But in the end, there were not sufficient facts to even continue the case to go to a jury trial. But it might have had the intended effect anyways.
She won the Democratic primary. So unfortunately, we're out of time, but I want to thank our Legal Roundtable for a terrific discussion today. Susan McGraw of St. Louis University School of Law, thank you so much.
Thank you.
And Bill Freivogel of Southern Illinois University Carbondale, thank you.
Thanks.
And Mark Smith of Washington University, thank you.
Thanks, Sarah.
Podcast episodes of St. Louis on the Air are available at stlpublicradio.org, or you can subscribe for free on Apple Podcasts, the Stitcher podcast app, or wherever you get your podcasts. St. Louis on the Air is produced by Evie Hemphill and Lara Hamden, with production assistance from Aaron Dorr. The senior producer is Emily Woodbury, and the executive producer is Alex Hoyer. St. Louis on the Air is a production of St. Louis Public Radio. That's 90.7 KWMU. Thank you for listening. I'm Sarah Fensky.
Support comes from the Missouri Forest Products Association. Missouri produces wood pallets, railroad ties, white oak barrels, hardwood floors, and more. Details on the variety of products made in the state are at choosewood.com.